Oh, okay. At the time it was made. This is from Matt Tissot versus Foster, 1989-90 Oregon Supreme Court case. We agree that meritlessness is necessary precursor to finding bad faith. Further, we conclude that for purposes of ORS 20.105, a claim, defense, or ground for appeal or review is meritless when it is entirely devoid of legal or factual, get this, support at the time that was made. So regardless of what follows in the way of specious, backdated assignment agreements, an evaluation of merit has to be at the time the claim was made, I believe is what this is saying. And in order for you to reckon 20.105, an evaluation of the merit is inescapable. And furthermore, a discernment of the motive. We need to know. I mean, okay, I mean, Mr. Byers, he's shown himself willing to pay for attorneys. And if he had merit, why wouldn't he just say, hey, why should we stop now? We have merit. There's merit here. He didn't stop a year ago and say, I'm happy to have the property. I'm happy to sell it to Mears. Go my way. He wasn't happy then to just be done with it. And so I would like to hear a good reason why he's somehow happy now. I found this case to be extremely helpful. Matisa versus Foster on the topic of bad faith, and there's three things: bad faith, wanton, oppressive. I mean, okay. Our income this year is well under the poverty zone. This is 11th hearing so far. We've had like 10 hearings in 2019. This has consumed an enormous amount of time. We're now in the poverty level. I mean, look at the time we've had to spend on this. I mean, does this not qualify as oppressive? In light of our effort to be conciliatory on adverse possession, isn't the rest of this clearly oppressive? We can ferret out cases to know ad nauseum to try to define and explain what oppressive is. Actually, this is really a cool case. It gets into the minutia of 20.105, and there's stuff in here that is very fascinating. When they evaluated this, the committee charged with developing the statute deliberately left to the courts the task of shaping the contours of the somewhat broad language chosen. So they explain in the history of this that it wasn't their intention to nail down the exact meanings of like bad faith. They even confess that bad faith can be ambiguous. And so we could play games forever about what the court thinks bad faith means or what we might think bad faith means.
Do you have the site on that case?
Who?
The site on that case?
The court reporter?
Yes.
It's 803P.2D723. And I thought we would be arguing prevailing party stuff. I mean, Jackson versus Mann was very thorough. That's where I learned that you can't have attorney costs without an additional statute such as 20.105. And it explains defendants as the dismissed parties. At one point, I was debating, well, what is the dismissed parties? I know what a dismissed claim is, but does the party doing the dismissing, are they the dismissed party? But in this case, the plaintiff dismissed their claims, and the defendants clearly became the dismissed parties.
Anything else on why your form of judgment is the one we ought to be using?
I did confess I wasn't able to get legal counsel. I did my best. I'm not trying to be outrageous, but with three defendants prevailing on 2 claims, and I have receipts to show the rest of it. with prejudice. I don't think it's fair for them to put us through all this and then be able to continue sue us again for trespass. They clearly, if the Mears want to sue us for trespass, that's their prerogative. But I don't think they should be allowed to sue us again for trespass. This is the second lawsuit already. I mean, the first lawsuit was like the original against the estate. And then at the end of the day, it's like, well, who did the trespassing? I was acting, I can cite the ordinances regarding personal representatives. I was acting as an agent of my family in doing that. So how can somehow heirs be singled out and targeted for, okay, you're going to have to pay or you're going to have to pay, as opposed to, they say that at all times I acted as a personal representative. So it concerns me trying to drag this outside the context of an estate matter. Okay, I mean, to just elaborate further. At one point, Stewart titled, they threatened us with attorney fees on claim 1. They said, we've spent 7 hours.
Stewart Title made that threat?
Yes.
Not Mr. Byers.
No. In December, I said to Tammy, if we give you the property and you can assure us there aren't going to be any attorney fees, we might sign the stipulated judgment. We spent 7 hours wasting time. At the end of the day, it says, Stewart Title is willing to drop any attorney fees for claim 1. And we don't know that parties are typically awarded attorney fees on adverse possession. So Stewart Title was willing to concede attorney fees on claim 1 when they really didn't have any grounds to do it. So I imagine,
Mr. Dyke, that still doesn't get us back to why your form is better than the one proposed by plaintiffs.
That I'm saying.
Plaintiff.
I mentioned Stewart Title in my, and I didn't get to put in the 20.105. I would like to put that in my proposed judgment. That's maybe about all there is there.
Okay. So here's what I'm going to do with regards to the term, or with the form of the judgment. I believe Mr. Tissot's form is accurate and correct in that it dismisses claims 2 and 3 as to Mr. and Ms. Dyke. And that's all it does. It doesn't alter the fact that they would be prevailing parties under ORCP 54. I think that's accurate. That they would both be prevailing parties on claims 2 and 3. Mr. Dyke's proposed judgment, there are a few issues with it. It proposes to dismiss it with prejudice, which is not what's outlined under ORCP 54. It attempts to foreclose attorney's fees, expenses, costs, disbursements, any other fees sought by plaintiff, which may or may not be appropriate, but then lists several non-parties, Stewart Title and the Mears. I can't do anything to them in this case. They're not parties. Same with dismissal of those claims with prejudice is related to those people. I can't do any of that in this case. It does attempt to deal with the prevailing party fee, expenses, attorney's fees, costs, and disbursements, which there is a procedure to go through to get those figures addressed. We'll do that if necessary. I don't believe the judgment proposed by plaintiff forecloses that. I'd also note that the proposed prevailing party fee includes the estate, which was not a prevailing party.
Gotcha.
I don't think you can object to my ruling. You can appeal it, but you can't object to it. They were defaulted out long ago, but clearly Mr. and Ms. Dyke are prevailing parties on claims 2 and 3. But the proposed prevailing party fee is in excess of what the court could award, even in the most egregious of cases. So I think plaintiffs is the appropriate one to sign. That's the one I'll sign. There are a couple of other motions which defendants have filed. I think I can address those pretty quickly. The motion for a settlement conference, I'll deny. There's nothing left to settle, given that the motions are being dismissed, or that the claims are being dismissed. There's nothing left pending.
Prevailing party.
Which the court will determine. That's the way that's
determine it without
pursuant to ORCP 68, which outlines what we need to do. The motion to find plaintiff and his attorney unreasonable, reckless, willful, malicious, negligent, and menacing. I don't see that there's any basis in law for me to make such a determination, independent of some other judgment that the court would need to make, such as for attorney's fees or prevailing party fees or something like that. So I'm going to effectively deny that by not addressing it. At this time, it may be appropriate to address with regard to the issue of attorney's fees or the prevailing party fees, but simply a motion to make that kind of a finding in and of itself, standing on its own, is not appropriate. The motion for sanctions that was filed regarding false misleading documents, false swearing, etc., identifies as the area of concern all statements that were either made in the motion for summary judgment or the complaint, which were effectively withdrawn by the notice to dismiss. Under Rule 17, if the alleged false certifications withdrawn within 21 days, the court can't award sanctions, so I'm not going to do that there. I've already addressed the motion to amend. So I think that covers it for things we need to address today. I will get the judgment signed today. If either party wants to move forward on the prevailing party costs, disbursements, etc. issues, we'll follow the ORCP 68 procedure. And I think that takes care of it. We're in recess. Thank you all very much.